Right, ladies and gentlemen, sorry for the slight delay, one or two administrative issues. If the fire alarm goes off, as there isn't a scheduled test, well, let's all assume it isn't a genuine emergency and Democratic Services will find a way out, come back, let us know, and hopefully we won't all be fried. Now, as people know, the Council is in the habit of recording these meetings as well as broadcasting them for posterity. Can I ask if anyone else is intending to record these meetings? That's not to stop you, it's just so we all know. No? Good. So, without further ado, I'll crack on with the agenda for this part of the compendium meeting. Apologies for absence. I've got one from Councillor Wilby, and Councillor Spooner, I believe, is also not going to be here, which is unfortunate. Any other apologies?
Thank you, Chairman. Councillor Eves as well. Yeah.
Okay, item 2, notification of substitute members. 4.
Councillor Chapeltay substituting for Councillor Spooner.
Thank you. Anyone else? No. Notification of visiting members. Councillor Webb. Thank you. Councillor Springett. Thank you. Councillor Burton. Thank you. Anyone I've missed? No. Good. Item 4, items withdrawn from the agenda. There are none. Item 5, any business the Chairman regards as urgent, including the urgent update report as it relates to matters to be considered at this meeting. We do have a short urgent update report. Is it agreed we take that? Thank you. Item 6, disclosures by members and officers. Are there any disclosures? No. Item 7, disclosures of lobbying we will take at the relevant item. Item 8, to consider whether any items should be taken in private because of the possible disclosure of exempt information. I'm not aware of any. Item 9, deferred items. Is there any progress on those, Mr. Bailey?
No update tonight, Mr. Chairman.
Right, so we turn immediately to the planning applications on the agenda. The first one we have is Oakhurst, Starbridge Lane, Marden, Tunbridge. I turn to the officer to introduce the report.
Thank you, Mr. Chairman, ladies and gentlemen and members. A couple of items just to update verbally. You've got it, members, you've got a red line boundary, amended red line boundary on your desks in front of you. If I could turn you to page 71 of your report, that has been amended, the red line boundary on page 71, and that is the one that you've got in front of you, which is a smaller red line boundary. The planning unit has been reduced. And also, if I could request a deletion of condition 3 on the officer's recommendation, which is on page 77 of the report, that has now been superseded due to the reduction of the red line boundary. So turning to the application, this is an application for the change of use of the land for the stationing of now 18 caravans. It was previously 20. They're holiday caravans with associated works, including laying of hard standing and the bin store. Members will recall this application came before Planning Committee on the 30th of May 2019. The original report is set out in Appendix A and B of your report pack, and members resolved to defer that application on the grounds as set out on page 72 of your report. I don't propose to cite them verbatim. The applicant has also submitted some following additional information as set out in paragraph 1.02, and again I don't propose to cite that again. So I'm just going to take members through a very brief, quick overview of the site. So this is the application site, which is here. This is the amended red line boundary, and you've got Oakhurst, which is the property, the owner of the property of this site down here, which is to the north of that site. Previously, the red line extended much further out to this boundary here, and now that has been reduced. Also, point to note that the caravan numbers have been reduced from 20 to 18. In terms of just familiarising members with, you can see this strip of woodland down here. The next slide will show you the delineation of the ancient woodland boundary. So it extends down to here and then cuts off in approximately this position about here. And that area is not included as ancient woodland, and nor is this bit just here. But I'll Oh, sorry. Oh, sorry, I was going off plan. Sorry, is that what I was waiting? Yeah. Okay, I do apologise.
I wonder why you look so puzzled.
I was off plan, so I do apologise for that. Hopefully, actually, the reasons why I'm off plan because it doesn't show on my screen, but I'll do it off this screen. So, this is the ancient woodland that I'm talking about, and the next slide I'm going to show you actually gives the definitive ancient woodland boundary. So effectively, it runs down here, extends down here, doesn't include this tip just here, and doesn't include this area of woodland down here. And I'll show you that in a bit more detail as I go through the slides. So this is the definitive ancient woodland boundary. So you can see this is the property, Oakhurst. This is the application site extending approximately down to here, and that is the extent of the boundary. And I've measured the approximate distance between the edge of the site boundary to the ancient woodland, and it's approximately 70 metres. So in terms of what the application proposes and buffers, it is a significant distance away from the ancient woodland boundary. So turning to the photographs of the site, this is a view looking northwards along Stylebridge Lane from the access where the car is, looking in the opposite direction. You've got good screening along the main frontage of the site with hedgerows. And this is looking inside the site. So obviously this is the front boundary of the site, and you've got Stylebridge Lane off to the left of the photograph. And that shows the front boundary hedging. The next photograph is the southern boundary. So if you refer to this plan, it's effectively that boundary along there, along the bottom part of that plan.
Is that flooding?
Well, ice and snow, it looks like to me. These fresh off the press, as I would call them. Obviously, everyone knows it was a cold day today. View towards the eastern boundary. This is looking over towards, this is the main, this is Oakhurst. This is the site. So I don't sort of tell any wrong information. You can see this white post fencing. Oh gosh, it's very difficult. Yeah. Apologise. Members can just see in this distance this white fencing here. The site boundary just extends outside that boundary and sort of runs along this area around here, so approximately including this area of this field. So this is the superseded site location plan that came before members on the 30th of May. This is the previous block plan, which is now superseded, where you had 20 units spread around a much larger site. This is the amended site location plan with the blue line land showing here. And this is the amended site location plan where you can see the ancient woodland coming down here, and the ancient woodland stops at this location here. So the distance I said of 70 metres is from this point to here, because this tip here doesn't appear on the ancient woodland inventory. So the distance from there to there is approximately 70 metres. You've got retained trees in this area, and you've got the buffer planting along here, which creates the wildlife corridor and the link to the pond area and the waterway at the front of the site here, which is what members requested, a greater link in terms of biodiversity from the front part of the site, the pond, towards the back part of the site. You've got the proposal for existing hedging retained along here, and the proposal for new hedging along here, the site. And again, what you've got in here is 18 proposed static caravans, and you've got the grasscrete in terms of the parking areas down here, with the roadway being constructed in this area. So this part does not form part of the application site and would require a separate planning permission for change of use in connection with the use for tourism-related accommodations in connection with the caravan park. So, in terms of changes that's occurred to the site since it last came to Planning Committee, there's been amended red line boundary, which effectively restricts the development to the front part of the site, and that retains the openness to the rear part of the site. There's been the introduction of greater landscaping use of grasscrete to soften the appearance of the development. Whilst it's not submitted in detail, the applicants have indicated low-level lighting in terms of bollard lighting, 125 millimetres high, to reduce the impact on the countryside. With regards to the concerns that members raised relating to more detail regarding scale and design, these are caravans. They're proposed to be static caravans. They are controlled by the Caravan Sites and Controlled Development Act 1960. That does stipulate the maximum size that caravans are allowed to get to under that particular part of the Act, which is 20 metres in length, 6.8 metres in wide, and a height of internal of 3.05 metres. And that doesn't mean these are going to meet that size, but there is, I'm just letting members know that there is a potential that if there's sufficient room on the site, and let's not forget they would be covered by the site licence, because there will be a requirement, separate legislation to get a site licence to cover this. Caravans could potentially go up to that size. In terms of landscaping and ecology, just to highlight, there's been no objection from KCC Biodiversity. There's been additional planting proposed to the ancient woodland buffer, which, as I said previously, exceeds the 15-metre Natural England Standing Advice. There's the removal, as you see on plan, of the eastern part from the planning unit. In terms of the concern raised by members to clearly demarcate and protect the ancient woodland and the buffer, there's proposed for triple timber post and rail fencing along the buffer areas, as you can see, to the southern part, moving to the eastern part of the site. And obviously, by the creation of that buffer area, that creates the wildlife corridor, which was requested by members to link to the front parts, the ponds, and that links to the greater part of the site and the ancient woodland that you can see hatched in green, albeit not covering all of that. The applicant also submitted a visual impact assessment, which concludes minor visual impact on the landscape. In terms of the request by members for a business plan, that was submitted as well and is quite detailed and set out in your officer's report. Policy does not actually require a submission of a business plan. However, that was a request of members, and that detail is set out in your report. There is no objection from Kent Highways, from the Lead Local Flood Authority or KCC Ecology on this matter. And overall, as per paragraph 4.01, the proposals accord with policy DM 38 of the local plan and, in consequence, the MPPF. So on that basis, the application has been recommended for approval, subject to those conditions set out on page 77 of your papers, with the request to delete condition 3 on that page number. Thank you, Chairman.
Thank you very much. I'll just ask the legal officer to outline how public speaking works.
Thank you, Mr. Chairman. Good evening, ladies and gentlemen. This is a short announcement for members of the public, and in particular those who will be speaking on an item on the agenda this evening. As you've just witnessed, the item is announced by the chairman. It's then introduced by the planning officer, and the chairman will then call the various speakers. When you hear your name called, please can you come forward to the table in front of you and take a seat. To speak, press the middle button. You don't need to hold it down. The button will turn green, and the ring around the mouthpiece on the microphone will turn red. You will have 3 minutes to speak, and you'll see the time counting down on the screen in the corner to my right, to your left over here. At the end of the 3 minutes, the chairman will tell you that your time's up. Once you finish speaking, please press the middle button. It will turn white and then return back to your seat. You may hear some of the speakers referred to as visiting members. They are members of the council, but they do not sit on this committee. They also have 3 minutes to speak, but they have no right to vote on any of the applications. Thank you.
Thank you very much. Right, the first speaker this evening is Mr. Cooper, an objector.
Evening. These are the findings of our legal solicitor. The application boundary still exceeds 1 hectare, so legally, regulation states tourism caravan campsites as Schedule 2 development that exceed 1 hectare do legally require an EIA. There is none undertaken here. Why? This policy does not comply with proposals. First report confirmed this site is located within an area sensitive to change, the Staplehurst Low Weald landscape. No information about the lodges. How can you assess whether this scheme will maintain or enhance local distinctiveness? How is it possible for you to assess whether it constitutes high-quality design? This is key wording in policy DM30 and stated to be fundamental in MPPF. You are advised that a caravan, as legally defined, is basic, but this misses the point. You are told conditions can be used to ensure holiday occupancy, but this is not the same as preventing a permanent encampment. No definition of holiday or limit to its length. Provided just one occupier can give another address, this encampment is permanent. Condition 6 only applies if all lodges cease to be in qualifying holiday use, yet you are still advised to agree to this permanent residential development in sensitive to change protected countryside. This report does not deal properly with this. You're advised that the permanent residential lodges are acceptable without demonstrating any market demand. You are not required to accept that, any more than you would do so for any other change of use. Members cannot conclude none of this matters. Applicants' obligation to make out a robust policy compliant case. This will be change of use of greenfield land to a permanent encampment, effectively a housing estate by another means. Application form confirms no employment will be created. So, First Officer report under main issues SP21 and DM37 are relevant, relating to employment opportunities in rural areas and expansion of existing business. Limited camping under permitted development is 28 days. 1 caravan and 2 tents have been seen in 3.5 years. That is not development. DM38 is said to prevent isolated residential uses in rural areas and permanent encampments. SP17 states development proposals in countryside will not be permitted unless it accords with other policies in the plan and will not result in harm to the character and appearance of the area. DM30 is blatantly not complied with. Despite parish and homeowner experience of flooding, the statutory consultees give no weight to that, which is surprising given the national concerns of climate change. If permitted and then viable, you would have opened the door to this becoming a traveller site. There is a very clear legal and policy justification to refuse. Members are not exposed to cost risk, given the clear policy basis supporting that decision.
That's time, sir. Councillor Mannington, Marden Parish Council.
Good evening. Marden Parish Council has already submitted its reasons for the refusal of this application, and I repeat, it would mean the introduction of vulnerable usage in Flood Zone 2. The proposal would result in the adverse impact on highway safety on a narrow country lane. It would have an adverse visual impact on the countryside. Noise and light pollution resulting from the use would be detrimental to the residential amenity of the area. Despite conditions being attached, should the application receive approval, the Parish Council remains of the opinion that this proposal is inappropriate in this area of the countryside, and subsequent information submitted does not alleviate concerns about the commercial viability of the project. The Parish Council continues to support the recommendation for refusal. Thank you.
Thank you very much for being so succinct. Mr. Nichols for the applicant.
Good evening. On behalf of the applicant, I thank you for the opportunity to speak in support of the officer's recommendation of approval for the application. As you'll know, members raised several concerns with this application when it was first debated in May. We were grateful that members afforded us the opportunity to reflect on those concerns and address them where possible. Some 6 months later, and I'm pleased to say that we firmly believe we have addressed all of the matters raised, in some cases going above and beyond what is actually required by relevant planning policies. One of the key but necessary changes was to adjust the application site boundary, as shown on the screens there. We were aware members had concerns regarding the proximity of the caravan park to the 15-metre buffer to the ancient woodland, as well as its spread across the entire paddock. Rather than just fence it off, which was the suggestion from members, we have opted to reduce the site area by 50% and confine the park to the western side of the paddock, providing a minimum separating distance of 70 metres between the park and the ancient woodland, as opposed to 21 metres previously. A low, unobtrusive triple post and rail fence has also been added to the site plan to mark the eastern edge of the park, as well as extend around the 15-metre buffer to the ancient woodland. Within the much more confined park, this in turn limits the amount of hard standing needed, whilst we're now proposing grasscrete driveways. And in combination with the retained paddock to the east, we've also added an extended planting zone to the south, specifically requested by a member at the previous meeting, which will add to the ecological benefits of the scheme. And in doing so, we've moved the visitor park along the inside of the hedge that lines the western boundary, putting it virtually out of sight from passers-by along Stylebridge Lane. In addition to the amendments to the site plan and in acknowledgement of the other concerns from members, we have completed a landscape impact assessment which revealed the development will have a minimal impact, which officers agree with. With no objections being raised by statutory consultees previously, it is not surprising that those same consultees raised no objections to the amended and additional details, which have also included a business plan, an updated surface water drainage strategy and an addendum to the planning statement. Subject to the conditions listed in the officer's report, material to the determination of this application is the fact that there are no objections to any aspect of this development from the Highways Authority, the Environment Agency, the County SUDS team, Environmental Health, the Biodiversity Officer, the Landscape Officer, the Agriculture Officer, Natural England, Kent Police, as well as the planning officers. Having demonstrated willingness to cooperate with the wishes of officers and members and having addressed all matters raised in consideration of this, we maintain that the principle of this development is acceptable and that this is an entirely appropriate development in this location in accordance with your development plan. We would therefore encourage members to accept the recommendation of your officers. Thank you.
Thank you. Councillor Burton.
Thank you, Chairman, members. I think we're actually looking at an application for a holiday park here. I have a suspicion that it actually becomes a residential park, but as a holiday park, I think we should be looking at its entirety. The business case that's presented by the applicants is useful. I note the consideration in there for £70,000 worth of hot tubs and decking, and they're an inevitable follow-on to this. So I really do struggle with the section in the report that says it's not justified to request further plans and details of the static caravans and the layout, because I think this is actually an item, it's an enterprise, and we're actually just looking in a very narrow way at this piece of legislation that says static caravans, and we've really got no idea what will actually be there. I am still deeply concerned about the flooding issues with the local knowledge relating to that. Flood zone 2, flood zone 3, it leads to an inevitable flood evacuation plan. Why would we be granting a permission where those risks exist, are known and are anticipated to be mitigated against? I think the previous speakers have actually covered many of the points. I'm deeply uncomfortable with this application. I also think that the suggestion for the condition to ensure that it's holiday use and not permanent residency is actually weak. A main residency implies that the majority of your time is spent somewhere else. I would certainly like to be seeing some limitation for the period of occupancy that's allowed, because I inevitably see these as permanent residential units, and as somebody previously had said, it's a housing estate by any other means. Thank you.
Right, look, couple of points. There is an urgent update which addresses one of the points made by one of the speakers and also sets out a further objection, so I'll note that. Can I take at this point declarations of lobbying as well on this application? Right. Now, just a couple of other points. We all know that local knowledge tells us a lot about highway issues and flooding issues, for example, but we also know that where the statutory consultee does not raise objection, that we can have all the local knowledge about everything that we have, but we still can't really raise an objection on that. Everyone will know the folly of the Environment Agency saying there was no flooding risk at Tovell Boatyard, an area which anyone who lives in the centre of Maidstone knows is extremely prone to flooding, but we insisted on putting it in and we came very badly unstuck there. So we have to be very careful what we do and don't object to. So really we can't have an objection on highway grounds or on flooding grounds. The issues resolve around visual impact, biodiversity and those issues that we were discussing earlier. So if members are minded to go down that particular path, then we need to look at those issues. One final observation on the business case. It may well be that we feel that you know, it's a suggested business and the business case should be there, but actually that's not a requirement of the planning law or the legislation, and therefore to say, no, you can't have it because you haven't, we have quibbles with the business case would put us in a difficult position because it isn't really an issue that, unlike certain types of agricultural application, which we can take that under consideration. Now, I don't think we've got a local ward member, so Councillor Mumford.
Just to clarify some points, I agree completely with Councillor Burton regarding, I think it's condition 4. I don't believe condition 4 goes far enough to ensure that it won't be used as a permanent residence. I would like some form of time. We see parks are closed some parts of the year, or if they record how long they're spending there, I would like to see some inclusion. I'm not happy with that condition. Because of the nature of where it's at and the ancient woodland, under a normal application, we would ask for a lighting scheme, an approved lighting scheme to be presented, and I'd like to see a condition on a lighting scheme included. And to the locals, I've lived there 65 years, that area will flood, but if the statutory consultee says it won't, we can do nothing. And that's the way it is. They're my starting points, so allow the officer to come back.
I think there is a lighting condition, Mr. Bailey.
Condition 15, page 80.
Sorry about that, Stephen. Right, Councillor Harwood.
Do you want me to?
No.
Thank you, Chairman. I mean, just to develop your point from earlier on, and Councillor Mumford's, I mean, we could challenge the Environment Agency in terms of their statutory consultee role, but we would need an evidential underpinning for such challenge, and we do not have that, though we do have an element of local knowledge. But frankly, in flood zone 2, that's a hiding to nothing. In terms of the highways issues, again, the Highway Authority, Kent County Council is very difficult unless we've got survey data and some other evidence that we can challenge their finding on. So essentially, we are just looking at the landscape and biodiversity impacts. And I do have to really kind of thank both the applicant and the officers for negotiating what I think is a much better scheme that sits much better in this very sensitive area of countryside. And actually, in terms of some of the issues around flood risk, the conversion from that improved grassland field to woodlands and scrub will actually improve the flood storage capability and actually allow better ingress of water into the ground because the tree roots breaking up the clay. So there's I think we've actually brought about a benefit through this improved scheme. So therefore, taking into account those issues, I will leave the officers to give us any more detail. Perhaps we do need to add an informative, or we do need to add some further detail to the condition on tenure. But otherwise, I am very happy that we do grant permission as per the papers, and they'll therefore move that, but with the caveat that the point that Councillor Mumford raised be addressed in some way. Thank you.
Councillor Harwood. Yes, before we go on, I'm going to come back to that point that Councillor Mumford raised. So I can see people, but I'm going to come back to that point because it's very quite important. Mr. Bailey, what can we do to make this condition more rigorous? I know that government guidance has moved away from closure periods, but what can we do? Because we know there have been issues in other local authorities in Kent.
Yeah. I mean, members are probably going to know what I'm going to say in terms of each application on its individual merits. We need to bear that in mind when we assess the application and not effectively tar the character of a potential site coming forward when we have enforcement mechanisms in place that can deal with that matter. But to answer your question directly, the Chairman is totally right. Some time ago, they brought out a good practice guide in tourism-related development. We used to have clear controls in policy and in national legislation that says put time limits on tourism-related uses that maybe 8 months, 10 months. Some of it was related to flooding in flooding areas. Some of it was related to, making sure you had a break in occupation. The government moved away from that and have moved away for quite a considerable period of time. There is no sort of policy advance in the MPPF for putting time limits on it. The MPPF seeks to support the rural tourism. Members could, if they so wished, decide to impose a time limit condition, but there would have to be reasons for putting that time limit condition. And if you say the reason is to prevent full-time occupation, that wouldn't meet the tests of the 6 tests in 1195 because you've got suitable enforcement arrangements in place that if there was a breach of that occupation, then there would be the remedy in terms of serving a breaching condition enforcement notice on the occupants of that park. So I'm not saying members can't impose it. I'm saying it's probably against good practice nowadays to impose it, but if you do, there's got to be very good reason in the reason why you're imposing that condition. So my view as a planning officer would be I don't see the reason for that imposition. I can understand members' concerns about what happens or has happened in potentially other parks in the borough where we've got full-time occupation. But effectively, we're wiping the slate clean here. You're granting a permission for a use of the land here. And there would be conditions imposed that could be monitored and controlled.
I'm sorry to keep belabouring this point, and we'll come back to you in a minute, Steve. So what else could we do? I mean, I suppose it wouldn't be feasible to just turn it around the other way and say that in order to maximise the economic benefit of tourism that we need that condition. That would probably be a little transparent. But what could we do to actually make sure that the issue is actually monitored and addressed? Because the issue in other councils wasn't that there wasn't a mechanism, it was that the mechanism completely fell down, if you see what I mean. It didn't happen. Well, it actually requires us to carry out checks, doesn't it?
Yeah, I mean, as we all know,
Yeah.
members, in terms of it is difficult with caravan parks, and to be proactive enforcement monitoring means, would it be reasonable to go around to sites like this every 2 years and monitor every single caravan park we have? Members may say, yes, that's appropriate use. In order to do that, that takes quite a lot of time and expertise with the level of activity. Quite frankly, I think it is difficult to impose a time limit condition, but I have said to members, they're not restricted on imposing it. You've just got to give good reasons why you are imposing it. And I'm struggling to find what good reason there would be in this instance to impose such a condition. So I am trying to be helpful to members looking around routes, but I'm struggling.
Okay, well, I think we might have to go the labour-intensive route then. Councillor Mumford.
We talk about conditions, and one of the main things is it must be enforceable. And with that condition, I can't see how it can be enforceable. So the reason for a time limit of some description, or being more descriptive than what we've got there, would be to make it enforceable, because there's nothing stopping a single person having a main place of residence, giving that, and then staying down there 12 months of the year. So how is it enforced? How do we gauge it? What's the standard? So both, I need it in there for enforcement purposes, because I don't believe what is written is enforceable. And if you want to turn the coin the other way, it was so the residents know what that condition means. It's to give information.
Councillor Harwood.
Thank you, Chairman.
As you move the motion.
When I move the motion, I mention the potential for an informative. And the reason I say that is because the condition, the relevant condition, is quite thin, it could appear permissive by omission to some of the intensification that has been described. So therefore, what I have seen used on a similar site in Ashford Borough is an informative which describes exactly, if you like, it's a hook to hang any later enforcement on by describe it. So instead of it being a rather utilitarian condition, it actually describes the fact that this is a tourist rather than a permanent residential setting, and explains the fact that it cannot be year-round. And by putting that informative on, if there subsequently is a problem, you've got a hook to go on to the enforcement step. So it's not unreasonable, as potentially a time limit would be, because there's no justification of any known risk, but it does provide, if you like, informative, as that is, like it says on the tin.
Yes, but Russell wanted to.
Sorry, I think as you pointed out, there is a difference between an enforceable condition and enforcing the condition. They're different points. So what you've got here, and looking at this condition itself, it is not too dissimilar to one to a recent planning inspectorate decision which I read. And in fact, the second sentence was a sentence which was specifically put in on that decision to make it enforceable. But just leaving it as a holiday purpose, people could live there permanently for a holiday purpose. So the inspector on that decision turned around and said that no such accommodation shall be occupied as a person's sole or main place of residence. So they have actually put it, and in fact, the parts which come after that, an up-to-date register and all that, the inspector actually took out of the conditions on it. So you've got a stronger condition, but the issue is a matter of enforcing the condition as opposed to having an enforceable condition.
Yes, I think that's what I said at the start. Mr.
Just 2 points. I think what I probably would suggest is maybe we add in the words bona fide after 4. So effectively, you're strengthening even stronger the term, because bona fide, in terms of it's got to be bona fide holiday purposes, not someone that's going to live there for 6 months and then go off to somewhere else for 6 months of the year. That's not bona fide holiday purposes. So I would add that in there. I do see where Councillor Hold is coming from. I think it's about drawing attention to future occupiers, which is where I glean that. And also, I should mention, in terms of site licensing arrangements, which is not a planning consideration, but it's done by our community protection team. And, you know, the issue is that what follows from, if members granted tonight, there is a requirement under the Caravan Licensing Act to get a site licence. That then follows the terms of the planning permission. So I think what Councillor Hart was trying to reference is, let's not get into the sticky situation where people buying that aren't 100% clear what they're buying into on the terms and the face of the planning permission. And if I glean that, that's what I think you're trying to achieve by the informative. So it's not using that as the mechanism to enforce, which I think the condition is strong enough. It's drawing people's attention so we don't get this situation as we have in other caravan parks. Because I'll be very honest, you know, members have said in terms of how we control the sale, you know, the business plan is very clear. Part of business parks is they sell caravans. Normally, they don't own the land that it sits on, but they're given a private license agreement with the owner of the land to station that caravan somewhere on that land for a period of 50 years. I don't know what the license agreements are in this instance, but that is a separate matter outside of planning. What we're looking at is controlling the use of the land, which is the caravan, and that's kind of an important consideration because the site licence will deal with other such matters that relate to permitted development rights, hard standing, safety, security, all those other matters. And it is important as part of a site licence requirement that the terms of the planning permission are shown on the site and published on the site. So that adds to that issue of drawing people's attention when they buy onto that site what they're buying into.
At some point it might be wise drawing people's attention to the fact might be best to actually make it specific in this informative that actually breaching the planning consent does mean that you actually do lose your right to be on that site under the licence. Because that's how it works, believe me.
Yeah, technically you're right, Chairman, but again, we've got to be careful we don't mix and match our legislation requirements in terms of site licence.
We can put in the informative drawing attention to the people, you know, within who are drawing up the site licence that this needs to be included. With informatives, it doesn't matter if you stray into other planning areas, non-planning areas. Anyway, Councillor Chapel-Tay.
The points I wish to raise, have been covered. They were exactly about the point we've just been discussing.
Have some water. Councillor Kimens.
Thank you, Mr. Chairman. I won't go on. I just wanted to second what Tony had proposed. I think compared to the previous application, that the reduction in size, the way the ancient woodland is, the screening, I think it's a vast improvement, and I'm happy.
Councillor Atkinson. Has someone got a light?
Thank you very much. Yeah, I agree with Councillor Harwood's proposal on the informative. I wonder if it would be helpful if we also showed date of arrival and date of departure in condition 4 in this register, which we're asking them to keep. Then that would be one way of being helpful towards enforcing the length of stay. And also, my old thing again under condition 16, I'd like to see specifically mentioned, if it's possible, bee swift and bat bricks, because you know, I don't know if you can actually fix them into these sorts of dwellings, but I'd like to see it done if that's possible. So, thank you.
Interesting one. Come back to that in a minute. Councillor Parfitt-Reid, I think you...
Thank you, Mr. Chairman. I mean, it does feel like we're sort of dealing with a fait accompli here. What I'm sort of struggling with is, why did we ask for a business plan if we can't take it into account? I mean, obviously, I understand we can't take into account the highways issue if there's no objection, the flooding if there's no issue, but we haven't looked at the sustainability of this site, and I do just feel it is in the middle of nowhere, and you're just plonking a load of caravans in a very, I don't know if anybody's been down that road, but it's a lovely, pretty, open bit of countryside, and those caravans, to be honest, I actually prefer that layout. I think the layout that's being proposed is just crammed in, and I don't like it.
Right, I think I think the problem with touring caravans and tourism by definition is that...
And my main point, which I never got round to, is I just can't believe also we're considering giving planning permission for something that we haven't seen the plans for. We don't know what these caravans are going to look like.
I think
We wouldn't let somebody build a house that we didn't know what it was going to look like.
Thank you. As I was saying, on the problem with tourism sites is that they do tend to be in attractive bits of countryside. That's the problem with, by definition, isn't it? But Mr. Bailey, if you could tell us where we've got to with this compound informative, and also address the point that Councillor Parfitt-Reid raised about design parameters for caravans.
Yeah, I mean, the difficulty with caravans are a use of the land. They're not operational works and they're not buildings. So the problem with the caravan is, as you know, on all these parks, they have a longevity and they have 15, 20 years and they need replacing. That doesn't require planning permission in order to replace a like-for-like, to replace a caravan within the definition under the Caravan Sites and Controlled Development Act 1960. So as long as it conforms to the site dimensions of the caravan, and I've set those out, 20 metres, 6.8, 3.1 internal height, then technically, as long as they conform to that, they are a caravan by definition. As for us to give an illustration of what a caravan looks like, I think I'd be deceiving to you, because the owner of the site might say, well, actually, I'm not having that caravan. I can have any caravan I want that falls within the definition, and actually, I would then be misleading members. So we can't really provide that information. All we can do is make sure that it meets the definition in the Act, and as long as it meets that definition, you get all sorts of...
So it won't be chalet style, or anything? They won't put in decking and stuff?
Well, if they come up with decking, it's a use of the land. Decking is operational works. Decking requires permission as set out in the report. So if they're going to come up with that, and that's clearly set out in the report, if someone's going to come in with decking, etc., which does occur, then that will be an enforcement investigation, and they'll need to say, well, it's operational development, you need to come in and submit a planning application for that basis. And I wouldn't say here what that would be. So come on to the final point in terms of where we are sitting with the informative that Councillor Harwood has requested. It's affecting, and Councillor Mumford, it's a question of drawing attention to the occupation can only be for bona fide holiday accommodation and cannot be for full-time residential occupation. And it may well be that I ask for delegation just to look in that in a bit more detail, not on the auspices of the night, to give maybe some example which I can put into the informative would assist any new occupier. You know, if you use the accommodation for 6 months and go abroad for 6 months, that is your sole residence. So I'll sort of expand that informative in a bit more detail, if that's okay.
Is there any merit to actually asking them to keep a record of when people come and go? Because it's quite a small site.
Yeah, that does set out in the condition, Chairman. It's where it does require them to maintain an up-to-date register of names of all occupiers and of their main, and shall make relevant operators of the caravan, but name, position, email address and postal address. Yeah. I mean, the difficulty, I suppose, you're on that point is you could ask for that issue and go through it, but it allows them to occupy it for 12 months.
No, what I'm just saying is
use it, sorry, not occupy it.
I'm just saying, on a relatively small site like this, I mean, if this was like New Beach or something like this, recording, you know, the day someone arrived and the day they left would actually be quite difficult. But on a relatively small site like this, I would have thought it's actually practicable. And if whilst you're looking into how the informative is worded, it might be appropriate to give some consideration as to how that information as to usage is recorded, because that would make it a lot easier to enforce a condition. I'm not saying a particular method now, but just to give it some thought as to how practical that would be, because I think it would make determining whether these are really holiday lets a lot easier.
I entirely agree. I'm just looking ahead at the enforcement regime where some of these homes would be owned individuals. People might turn up at any time of the night they want to. And, you know, the issue is if there aren't those names recorded in the register, is that a breach of that condition? Technically, it would be if the full detail is not filled out and I go on site and there's no record. So
I'm just saying, I'm not expecting you to come up with a full answer now, but I'm just saying if you're asking for delegated powers to consider the details of the informative and getting it right, can you also at least consider the point that I just made, you know, as to how we actually monitor the address names and addresses and so on to the most effective way as part of the delegation. I mean, that's acceptable to Councillor Harwood and Councillor Kimmentz, of course. Anyone else? Otherwise, I am going to Councillor.
Yeah, it was just something that Councillor Parfitt-Reid said about it being in the middle of nowhere. To somebody like myself that was brought up on a council estate on top of lots of other people, being in the middle of nowhere is the attraction. It's like that's my kind of heaven. So I can understand why people would want to live out in the middle of nowhere for a few months of the year and use it. I mean, I'd take my dog, I'd walk my dog, I'd sit there, have a bottle of wine, walk up to the shop, even if it was 3 miles away. It doesn't matter to me. That's my kind of heaven.
Yeah, I think we are generalising on general principles. Not conducting a survey of 99 out of 100 canines' preferences for holidays, but although that would be interesting. Right, anyway, I think we've been fairly clear where we are on that. Now, the amended recommendation. We have an amended recommendation, including the delegation to solidify the wording of the informative and look into exactly how the enforcement regime could work. Any other tweaks? Otherwise, I'm going to put that to the vote. Sorry? Well, yes, I'm not quite sure how practical it is, but in terms of, I've never seen a swift brick in a caravan, but or a bat box, but. So I'm not sure, but how we would do that. I think we might need to give that some more thought. So if members were minded to look at that, but because I'm not sure how you'd do it, but I wouldn't want to rule it out, Mr. Bailey.
Thank you. Yeah, I would agree. It might be difficult to impose. Because I would hopefully, in terms of the buffer areas, we're getting that ecological enhancement through that buffer area. So I think if we're adding swift bricks to caravan might be difficult.
Yes, I think Councillor Mumford.
He's broke my thing. The nature of the ground all being open fields right next to the river, we could ask for owl boxes. They would get occupied in that area. Yeah.
Much though I would prefer ale boxes, but we're not quite there. All right. Those in favour of the amended recommendation, please indicate. Those against? Are there any abstentions? I don't think so. No. Okay. Thank you, members. Right. And we will be watching to see what happens with the enforcement issues. So, yes, we will be monitoring this one quite closely. Move on to Durrance Farm, West Street, Hunton.
Thank you, Chairman. This is an application, an outline application for demolition of existing buildings and erection of 8 number dwelling houses. And as an outline application, it is considering access, layout, scale and appearance to be considered now, with landscaping reserved for future consideration. This application has been with the council for some time, as you'll note for the date. One of the stumbling blocks, if I can call it, is the difficulties with DM5. It's a high bar policy and obviously links in with SP17. So our DM5 is our brownfield policy, kind of exception sites coming forward, and this is one of those that we're looking at. There was an issue obviously due to its site area and its contributions to affordable housing and how that was dealt with, and I'll address that in the report as we move forward. So turning to the site, I'll have to do this plan. So this is the red line is the application site boundary with its associated buildings, and I'll come and show you. You'll notice on this site one of the key considerations in this application is the lawful development certificate on the site that established workshop and open storage in connection with the demolisher's yard. So whilst that whilst the site use is very low key at the current time, members would have to bear in mind that the fallback position, i.e. the established use, could see significant intensification of that use at some time in the future, which can cause significant harm to the landscape character. So that has to be balanced against the benefits that arise from this scheme. So just looking at the aerial photograph of the site, this is Darrant's Farm. You've got Darrant's Farm just in here, and you've got Darrant's house, which is this building here, closer view of it, which is this building here, which is a Grade 2 listed building. So, sorry, again, I forgot. Sorry, you've got Darrant's Farm, which is over here, which is the application site, and then next door, in terms of you have Darrant's house, which is a Grade 2 listed building, and therefore you have a duty to consider the setting of Darrant's house as part of your consideration as part of this application. The officer sets out that there would be a significant improvement as a result of the lawful use of the site as a builder's yard, and that weighs in the balance in terms of the consideration tonight. Moving through the application slide, so this shows the access onto West Street, just off to the right here. And this is access going down the existing track, the farm track. The area of land over on this side is not part of the application site, but it is within the applicant's ownership, blue line land. These are Darrant's Farm and the other buildings that you can see in the background. Again, Darrant's Farm, looking at the house on the site, the yard buildings, and again further yard buildings. And as I said, what I'll come into next. So this is the extent of the lawful use of the site. So this is where the lawful development certificate was established, which allows for the workshop and open storage areas in connection with the demolition contractors, which I said sort of weighs is quite a weighty consideration as a fallback consideration in this application. This is the closer view of the extent of the existing buildings on the site. And as set out in the officer's report, this was a previous design which caused quite significant concern with local residents and the parish council in terms of its very contemporary design and its inappropriateness in the context of the site. We've moved on from that stage. That was indicative at that stage, so because appearance wasn't considered when originally the application came in, appearance is now being considered. And this is an example of a house design that's proposed on site for a 4-bed. This is a house design proposed for a 5-bed. And then moving into the layout of the site, this shows the proposed layout of the site. It's arranged around a sort of a central area Members will note that you've got, from the aerial photograph, very established hedging down this side of the site, and there's proposed to be additional landscaping pushed around this area of the site. It's a very inward-looking site in terms of its development and is well screened. You can see the setback from the road. It has got established screening around the site. You have your fallback position that is part of a consideration as well. So, turning to the application, the key issues are set out on paragraph 7.1 of the officer's report to consider, which is page 59. In terms of the concerns raised that the site is comparable with the call for sites for the current local plan, that was a much larger site. This application includes the lawful development certificate site and the site and the house and the residential curtilage for Darrant's Farm. So it's a far removed consideration from the local plan process, but notwithstanding that, an application and a site allocation is a very different process that needs to be followed, and each application needs to be assessed on its own merits. As I've said, the fallback position is a significant consideration in the determination of this application. And I've set out in terms of members what that fallback position is. Policy DM5 and SP17 is the key policy here in terms of MPPF paragraph 11, which sets out for us to sort of look at the key policies for consideration in this application. And policy DM5 sets out a detailed criteria that needs to be followed. And I'm not going to go through in the full detail in terms of what DM5 sets out, because that's set out in the officer's report. And there is assessment made on that consideration. It is an exceptional policy. In terms of what the policy says, it says where exceptionally the residential development, which are not residential gardens and which meet the above, will be provided where redevelopment will result in significant environmental improvement. That is one of the key considerations. The report does acknowledge that the sustainability criteria is not fully met in terms of the latter part of the policy. And for members' information, that says that the site is or can reasonably made accessible by sustainable modes to Maidstone urban area. Now, there is a bus service. There's a bus stop about 400 metres for the site. It's acknowledged that that is a weekday infrequent bus service in terms of the time. So I'm not trying to turn around and say the site meets that criteria. I think the officer is clear in the basis that I'm pointing out to members there is that bus stop, there is a bus service. It's not great in terms of serving the local community, but it is there. The officer's report sets out that clearly that part of the policy isn't fully met and cannot be fully met, but balancing against all the other considerations, the lawful use of the site, the environmental improvements, the design issues relating to the site, that taking all those matters into consideration, that the balance weighs is in favour of granting planning permission on this site. There is, lastly, in terms of the issues, in terms of a viability assessment, as I set out at the start, affordable housing, there is a requirement due to the site area to consider affordable housing on this site. There was a viability appraisal submitted by the applicant, which has been tested and verified by an independent consultant to say that the site cannot sustain affordable housing on this site with those numbers. However, they have suggested a clawback mechanism, which the officer has recommended to be secured by Section 106 agreement. So taking all those matters into consideration, members will note the recommendation on the report, which is to approve planning permission subject to the Section 106 agreement and subject to those conditions listed. Thank you, Mr. Chairman.
Thank you, Mr. Bailey. Ms. Harvey for the applicant, please.
Good evening, Chairman, members. This application relates to the redevelopment of an existing commercial demolition yard in the countryside, which is currently unfettered by planning conditions and causes a severe loss of amenity to its nearest neighbour, Durrant's House, which is Grade 2 listed, and wider negative impacts on the village, such as a result of HGVs accessing the site from the wider local road network. Our proposal seeks to make use of local plan policy DM5, which allows for the redevelopment of brownfield sites in the countryside, provided they meet the relevant criteria. The application would ensure that the built development is confined to that certified in 2007 as a demolition yard, thereby consolidating development compared to the current proliferation of open storage, hard standings and various commercial buildings. Whilst 8 houses are proposed, their scale and layout have been designed to ensure that the scheme results in a visual improvement to the rural amenities of the countryside. The application has been amended to reflect local concerns regarding the external appearance of the houses, and the case officer is now satisfied that the design and layout proposed are appropriate for the site. The matter of appearance has since been included within this outline application to give the council the assurance that this matter is not open for negotiation at reserved matters stage. KCC Highways are satisfied that this scheme would represent a benefit to highway safety compared to the existing unfettered lawful use. In terms of sustainability, the village is served by 3 bus routes, and whilst there would be some reliance on the car, this should be balanced against the significant wider material benefits of this scheme. In terms of biodiversity, in liaison with KCC Ecology, we negotiated the ability to carry out site-specific survey work after determination by providing a worst-case scenario mitigation strategy. It has been agreed that once survey work has been carried out, it is submitted for approval alongside a revised, tailored mitigation strategy. Nevertheless, the principle that the site can provide sufficient mitigation has been established. In terms of affordable housing, our clients have provided a robust viability appraisal, which concludes that a contribution to affordable housing is not achievable. The council's own independent assessor has corroborated this view. However, our client is willing to accept a clawback provision within a Section 106, which will ensure any increase in sales values, which result in an increase in overall profit, will be split 50-50 with the council as requested. Accordingly, it is considered that the proposal would result in the removal of an unneighbourly commercial use, allow for the decontamination of the site, improve the setting of the adjacent listed building, improve highway safety and remove noisy HGVs from the site, enhance biodiversity, develop a well-screened inward-looking site with little impact on wider views, and provide a well-designed redevelopment of a brownfield site in the countryside in accordance with policy DM5. Accordingly, it is hoped that the committee will support the officer's recommendation and grant planning permission this evening. Thank you for your time.
Councillor Richard Webb, please.
Good evening, members. Sorry, I've come straight from work, but Hunton Parish Council were hoping to speak, and due to the misunderstanding, they have asked me to talk. Whilst they are not totally against the proposal, because they would like to see the removal of the demolition yard, they are worried about the amount of houses that are on this development. There are proposed 8 houses. Unfortunately, 4 of the houses on the plans would be south of the application that is there for the demolition yard. The parish council would like to see the 4 houses that are south of this to be removed from the application. They feel that there are too many houses for this site, which is in a small rural location. Hunton is not a very large village. It does not have that many large estates in the rural area like this. They are also concerned, if we look at the plan that is on the boards at the moment, this seems to be a mirrored development. Either side, their houses are all very similar to each other as they go down. And this cul-de-sac, really, they feel would be much better for a urban estate rather than a rural site. They feel that if there was a more, I've put hodgepodge design rather than a formal road through. It would be much better for a rural area, and they would wish to see some consideration to the layout that has been put in, not being specific for this rural location. And they would really like that if there is a difference of opinion here between members, would there be the possibility that they could perhaps have a deferral and they could then talk to the developers about changing the application to a more reasonable number that would fit into the area of Hunton? So thank you.
Thank you, Councillor Webb. Can I take any declarations of lobbying at this point? No? Okay. Right. I could be wrong, but I think cutting an application in half, numbers in half, is probably requiring a new application rather than a deferral, although I can see the logic of the argument. So that's probably a little more than we would gain from that. Councillor Harwood. Apologies, yes, of course I keep forgetting it's Coxheath and Hunton rather than just, because for many years it was just Coxheath Ward. Councillor Parfitt-Reid.
Well, I'll be quite brief really, because I really just want to reiterate what's been said by Councillor Webb. I'm not opposed to the principle of development on this site, and I do think it would enhance the village if that brownfield site was developed. I think there's some slight inaccuracies have been put forward about it being hidden from view, certainly not from Bishop's Lane and Water Lane. You can see directly onto that site. So that's, I would want that to be taken into consideration. And again, for me, it's the design. Richard came up with a really good expression, a mirror, and I just don't, it looks like a cul-de-sac. And I think what I would like to see in terms of design, what I would like to see in terms of design is something that incorporates what it would have been, which is a farmyard, which is a bit more higgledy-piggledy, some smaller properties, some bigger properties. So it looks like the development of a farmyard and more in keeping with a rural community, rather than something that would probably fit quite well into, you know, say Coxheath or a more built-up area. But I think for me it's the design of it's the number of houses and the design of the actual site itself, I think, is not what I would want to see.
Thank you very much. That's admirably clear. Councillor Harwood, I'm sorry to have tried to bring you in too early.
That's fine. This whole report made me quite, I mean, not this report specifically, but all the papers made me furious, which as well as other things. But this one particularly so. I am really struck that we're losing employment sites from the rural area. We're having them asset strip for housing, left, right and centre. And the Kent countryside is a combination of employment sites. Some of them are like this. And if we say that that is justification for getting executive estates on every yard in the Kent countryside, I think we're on a very slippery slope. So I think there is policy in our local plan and in the MPPF to protect employment sites, and particularly those in the countryside. So that was the first and foremost issue. Then there was the sustainability issue. And that is sustainability in terms of, you know, they're talking about 16, possibly 32 more cars, which is certainly more than the one HGV which is operating out of here. So I think that there is a very significant traffic generation. I hear the talk about affordable housing, you know, for a vulnerable person, which is frankly where you need to be to get usual. To be plonked here, it was totally unsustainable for that person. And then I come on to the design. And what we have always sought, if it is an open rural area such as this, and you see it across Bishop's Field, which is as flat as a pancake, you see it from Bishop's Lane, it is quite an open site. We have got, it reminds me of Captain's Close in Sutton Valence, for anyone who knows it. I mean, that's what it looks like to me. does not look, as you say, like a kind of a pastiche farmyard or whatever, but even then, it would have to be good design to comply with the MPPF, and it would have to be sustainable. There's no renewable energy put in here. There's nothing about integral niches for wildlife, when clearly this is an area where potentially there's barn owls and tawny owls and bats and so on that need to go in. It's just a poor urban design plonked into very open countryside. And I was just more and more amazed as I read the article. And when you talk about, it's an improvement for biodiversity. Well, not when you get about 20 cats move into the area and eat all the local biodiversity. It is the countryside in its truest sense. So I actually think that we should, as a committee, act in the way that we always have done on applications such as this, and refuse it on the grounds of its unsustainable location in the loss of an employment site, and the fact that it is in the open countryside and incongruous with the open countryside by the form of development, and that's both the cul-de-sac and the architectural design. And there's the issue around sustainability. It's not sustainable development in the meaning of the MPPF. It is not even attempting to do that. And I'll leave it at that. But I was very unhappy with the report. Thank you.
Yes, thank you, Councillor Harwood. Before we go any further, can I see whether that is seconded? Right, Councillor Mumford, you were fractionally first. Do you wish to speak to that now? I would suggest it because this won't be a long debate.
No, I will. If we're looking for the reasons, it's policy DM5. It's contrary to policy DM5 in the layout and density of the new housing proposed does not reflect the character or appearance of the individual location.
Right. Does anyone want to add anything to the reasons, grounds? No, in that case, does anyone wish to add anything new to the discussion?
I just wanted to add one small thing, which I didn't say in my initial statement, was it has been identified that in Hunton there is a requirement for smaller housing as opposed to these larger 4 or 5 bedroom executive homes. And so perhaps the applicant, if they are minded to resubmit something, might take that into account.
Thank you. Councillor Perry.
No, I'll be very quick, because I agree with everything else. Oops, I got it. Okay, now I do agree. I think the sustainability argument is crucial here. We have to be consistent. And when I read this, I thought, God, it's not sustainable. It can't be. We've rejected other applications for that. And the other thing is the design. Well, I think there was a training program on Monday here about design for living, and I think this doesn't meet any of those design principles. So on all those bases, this needs a rethink. I'm not saying it's, but in principle, it shouldn't come back at some time, but it needs a rethink. Thank you.
So what we're saying is that, notwithstanding the small contribution, the contribution a small number of houses would make, that by virtue of the unsustainable location, the design issues, in other words, constituting the suburbanising design in the open countryside, that we feel on balance this application should be refused. Basically. I'm sure Mr. Bailey may want to tweak that slightly. He's assiduously writing.
I kind of know where members are going with this, and I have got the key elements which I would ask delegation down to the Head of Planning and Development, but I get in terms of the proposed development by virtue of its poor and inappropriate and incongruous design, its density, its poor sustainability and lack of exceptional circumstances as set out in policy DM5 of the local plan, and I would also refer to policies SS1, SP17, DM3, DM5, DM30. What I would add to members, obviously, Circular 06/2005, there is a mention towards the back end of the report about bats. Are members satisfied in terms of the ecology matters that have been set out in the report? in
No, I
terms
don't
of the
think-
studies? Because
no,
obviously the biodiversity officer is recommending further work on that. What I don't want to do is for that to be pulled up at a later date. So I just ask members to give us a steer on whether they're satisfied with the
unless I completely
protected species.
misunderstood him, I don't think Councillor Harwood was satisfied.
No, I specifically mentioned not just bats, but owls in terms of both loss of habitat and the fact that there is no substitution in terms of integral niches, which are not just supported by the 2005 circular, but also by the 2019 MPPG.
Sorry to come back. It's just the issue of bats obviously are protected under the habitats regulations, and on the basis they carry a much weightier decision basis. So I just wanted to draw members' attention on, in terms of derogation, what circular does say in terms of habitats species under the habitats regulations. That's why it says you should have surveys up front so you know the impacts. And obviously that's why it says only in exceptional circumstances should you condition them. The officer has considered, in this case, there are exceptional circumstances to consider. Members may consider that there aren't, and therefore they require that information up front. It's up to members how they wish that to be dealt with.
Councillor Harwood, and quickly, and then because I want to bring this to a close.
Well, yes, because clearly we need to follow the regulation, and we must do that. But there is another quick point, particularly fits in with the incongruous impact within the open countryside, is that we would need a design-led approach if it was anywhere near going to be an exceptional scheme that would be supported by this committee, to just defer things like the landscaping in such an open area to be an afterthought is ridiculous. So it's not just the built design, it's the layout and it's the landscape design are all emissions.
Yes, I think that's very clear. Okay, anything else you need? Otherwise, I'm going to the vote. Mr. Fitzpatrick.
James, sorry, I think Councillor Howard mentioned loss of employment. Is that...
My advice would be not to include a loss of employment site on this, because obviously we don't have a policy regarding it's not an allocated employment site, and we don't have anything that protects unallocated employment sites. So my recommendation would be for members not to include the loss of employment. You have substantial grounds that you've already cited, and I've got a second ground of refusal relating to not following the procedures adopted by 2005 on protected species. So I'll include that in the ground, but I would suggest not loss of employment.
Which is something we possibly need to pursue at another committee, because we're constantly tripping up on this one. So I'm going to go to the vote now, unless this is...
Sorry, James, and did you get the unsustainable location?
Yes.
Is that in there?
Yes.
Okay, cool.
Okay, those in favour of the amended recommendation. Councillor Harwood, are you going to change it again? No? Right. Okay, are those in favour of the amended recommendation to refuse for those grounds? That's everyone, so no further votes to take. Right. I am now going to adjourn for 15 minutes for tea.
Right, good evening, members. Moving on to item 21 on page 148, and as Councillor English mentioned, Mr Dawkins is unable to speak, so I therefore call Councillor Val Springett on it. No, we also.
You could introduce them.
Yeah, okay.
Okay, this application is for the renovation of an existing dwelling, including a two-storey rear extension, alterations to the front elevation, part first floor, part two-storey front extension to the garage. The area is suburban with detached two-storey properties of varying designs sited relatively uniformly along the road. A couple of concerns have been raised by the neighbours with regard to neighbour amenity and the character of the area. So you can see the location plan on the screen now. In terms of the rear elevation, the two-storey extension would be a little over 4 metres in depth. The two windows at ground floor would provide secondary lighting to the living areas on the neighbouring property. And as the extension wouldn't extend beyond the rear wall of the neighbour, the potential impact on the conservatory and other rear windows would be minimal on the neighbouring property. The siting of the extension would result in the dwelling being more in line with the neighbours. So in terms of overbearance and overshadowing, any potential impact would be alleviated, and there would be a condition attached to the application for obscure glazing with the two bathroom windows and the secondary bedroom window that's proposed on the flank wall. In terms of the garage, on the next slide. Right, this garage here has been extended and would now be 4.6 metres in height with a depth of 6.2 metres. There is an existing fence that runs along the boundary, which is going to be retained, and the proposal would increase the height of the eaves from 1.9 metres to 3.2 metres, and the overall height from 4.6 metres to 6.6 metres with a pitched barn-hipped roof. Number 32 has windows in the rear elevation, with the closest one serving a study. In terms of the loss of light, the 45-degree light test indicates some loss of light on the plan, but on the elevations it would pass. So on balance, there'd be some increase in bulk and massing, and the proposal would not result in any significant loss of sunlight or overbearance issues to the neighbouring property. The character of the area was also commented on. The landway is a mixed street scene with varied buildings in terms of design and height. In its context, the proposed development would not appear significantly out of character with its surroundings. And although the proposed extensions would almost double the size of the existing property, the majority of the development would not be visible from the highway and would sit comfortably within the site. The front building line of the property wouldn't extend further forward than the existing building, and the alterations to the front elevation would amend the design to incorporate a double gable whilst maintaining the position of the existing front wall with the entrance recessed centrally. The application is recommended for approval, but a condition would be added with regard to obscure glazing to ensure the neighbours' privacy isn't compromised. That's it. Thank you.
Right, thank you. Councillor Springett, sorry for full start, I was rushing through it. So you've got effectively 6 minutes, 3 minutes.
Yeah, I've no idea how, I've only seen this
yeah.
evening,
Okay.
so do apologise, I've no idea how it works time-wise. This is the objection from Mr Dawkins. Mr Dawkins lives in the property that is that side of that picture. So he is the house most affected by this. So I'm reading it in his words. I strongly object to the planning application under the above reference. It has been acknowledged that this planning application, if approved, represents a significant extension to the original property. The proposed external gross area will almost double in size, and I have particular concerns about what I would describe as a substantial double-storey left wing elevation to the existing building. This wing would overshadow the right side of my property, severely reducing the natural light to both the ground and first floor. I have 2 side windows in my lounge, each measuring 1 metre wide and 68 centimetres high, that would be directly affected by the construction of the left flank elevation, as the sun would never reach them due to overshadowing. I am retired and spend much of my time in the lounge, and the significant reduction in natural light would have an impact on my current health condition and well-being. Similarly, in the bedroom on the first floor that I also occupy, I have a window measuring 53 centimetres wide, 1 metre high, facing the proposed double-storey left flank elevation. This would also be adversely affected by a severe reduction in natural light and overshadowing. The rear of the left flank elevation also protrudes past sections of my recently built conservatory, and that will cause overshadowing. In addition to the lack of light, I consider that the bulk of the proposed left elevation will impact on the loss of privacy, because there are large windows on the first floor at the rear that would overlook most of my rear garden. I have a patio in my rear garden where I enjoy private conversations with my family, and the close proximity of what is proposed would clearly impact on this private social space, as distance between the rear of the proposed wing and my areas as described will be significantly reduced compared with the existing house. The proposed Marley roof tiles do not fit in with the neighbouring houses, and the sheer bulk of what is proposed would compromise what I would describe as an existing attractive family home. So that is the objection from the adjacent resident. I'll now go on to my objection. If anyone's seen 29 The Landway, by the way, the monster, this is another one. Good evening, members. As usual, this comes down to interpretation of policy. DM9 is intended to give some protection to existing residents from adjacent development. The officer is giving little weight to this policy, and I disagree. Members, please correctly weigh up the effects of this proposal in terms of loss of privacy, daylight, sunlight, and outlook for the adjoining properties, and the impact on the street scene. This proposal will almost double the size of an already large house and change its character significantly, so it will look out of place. The bulk and mass of the proposal, combined with the changes proposed to the front elevation, will completely change its appearance and will overwhelm the original house, contravening policies DM1 and DM9. The officer agrees in paragraph 2.06 of her report, stating that the dwelling would significantly change due to the design, materials and fenestration, and in paragraph 6.06 that the proposal will significantly change the appearance of the existing dwelling. There are 2 windows on the side wall of the property to the north. The outlook from these windows will be changed from a relatively light and open aspect to one of a 2-storey flank wall. And as the application property is to the south of it, this will cause a loss of direct sunlight into the lounge and rear bedroom of that property. The officer agrees that there will be a loss of light, but says it will not be significant. A loss of light you have enjoyed for 30 or so years is a loss of light and clearly contravenes the intent of policy DM9. The amenity of number 32, the other side, will also be impacted, as the adjacent garage building will increase in height by 2 metres, causing a loss of light and giving a claustrophobic feel to the rear patio area. The complete change of design and materials to the front elevation and the inclusion of what appears to be full height windows will be completely out of character with the street scene, and this property will stand out like a sore thumb. In 6.09, the officer says that proposed materials would appear sympathetic with the mixed street scene. I'm afraid I very much beg to differ, as this and its neighbouring properties are of a particular style and blend well with each other. Members, please correctly apply policies DM9 and DM1 and refuse this application on the basis of unacceptable impact on privacy, daylight, sunlight and pleasant outlook of adjoining properties and unacceptable impact on the street scene. Should you be minded to approve it, please consider deferring it for the relevant light test to be carried out to ascertain just how much direct and indirect sunlight is lost at number 36. One last paragraph. It is disappointing. Okay, all right, thank you.
Thank you.
Thank you.
Right, members, can I have indication of lobbying in this application? One. Yeah. Okay. Thank you. Anybody indicating wish to speak at this point? No? Right. In that case, in relation to this application, I take on board all the points that have been made. However, the residential extensions SPD does talk about renewable energy generation, and there is no reference in it to that, and it's quite a large extension, and I would have thought it was at least deserving of that design conceit. Right, I'll bring in Councillor Kimmants first anyway, see if there's any other issues.
Yeah, I mean, I would be concerned about, because you see me got up and I had a look, and I saw that there's a conservatory on the back, and what would concern me is the loss of light in the conservatory. And you mentioned about doing the light test on it, so I would be inclined to defer and have a light test and to see whether it is going to be overbearing on the conservatory, because the whole point of having a conservatory is to let in as much light as possible so that you can sit there and have the sunlight beaming through your conservatory.
Right, can I bring the officers in at this point around the conservatory issue and the design issue that was raised?
So in terms of the conservatory, the application has been assessed, and it was found that that the basic tests that are carried out by officers, it passed sufficiently for us to say that there isn't a problem in terms of loss of light. Obviously, you've got to, there will be some impact, but it's not considered to be excessive enough to warrant a refusal of the application. Can I also say, in terms of the windows on the flank walls of the neighbouring property, these are secondary windows, so you know the main windows to the living areas are on the front and rear of the property. So although again I would say yes, there will be some loss of light, but because the primary windows are on the front and the rear of the property, well, that's what we would look at, is that they do have sufficient light. Sorry.
Right, thank you. I'll bring it. Do you want to come back on that point? Okay, go on.
Yeah, secondary window. A window is a window. It lets light in.
Councillor Mumford.
Yeah, reading through DM9, you look at the privacy, and I'm concerned about the privacy of the garden, the patio area. Daylight, sunlight is to be maintained. Now the officer's saying that it will be reduced. Well, that's different than saying it will be maintained, and the policy definitely says that the privacy and sunlight will be maintained, and the pleasant outlook. And I feel that the scale, the height, the form of this building wouldn't give you a pleasant outlook. And I'm on the border of saying that because...
Are you moving something there?
Yeah, I'd like to move that this is contrary to DM9, the scale, the height, the form and the appearance affects the neighbours' amenities in privacy, daylight, sunlight, and maintaining a pleasant outlook because of its size, its form.
Okay, and is that motion seconded? Right, Councillor Parfitt-Reid, I was going to bring you in next anyway, so as a seconder, if you want to come in.
Yes, you've just said exactly what I wanted to say. I mean, for me, it's the loss of privacy and the outlook. You know, those two side windows are going to be in such close proximity to the neighbours, and yes, so that's why I second what Steve has just said.
Okay, thank you. Councillor Perry, do you have anything?
I'll be very quick. I totally agree with Councillor Mumford and Councillor Parfitt-Reid. Thank you.
Yeah, if I bring in the officer.
In terms of members, it's a kind of a standard rule in terms of secondary windows that you have to demonstrate there's harm to the living conditions of that occupier. So in terms of primary windows, those primary windows are not going to be affected to the degree that would be sufficient to warrant a refusal in this application. In terms of impact on secondary windows, that is acknowledged that they're not used for primary purposes, for sitting in, for kitchen areas. They're used on a secondary element. So I don't think you would be able to sustain a ground in terms of impact on those windows. So what I would ask that members need to clearly clarify exactly where the impact is coming from and on which property, so a properly constructed ground of refusal can be made. And I haven't heard that at this time. All I've heard reference to is the secondary side elevations. I don't think that that is a ground to refuse this on. And I would request that members articulate that a bit more, please.
Sorry, Councillor Chapel-Tay, please.
Mr. Bailey, are you saying that if we reject this on the grounds of loss of light, we might then lose it on appeal should the applicant take it to an appeal?
Thank you. I think that's understood, and I think that Councillor Mumford is going to expand upon the grounds for refusal now. Thank you.
Yeah, the officers interpret things differently than me, because if I get a policy and it says that the daylight, and this is something that went through full council and has been through a government inspector, is to be maintained, then I'm sure I can use it because it's in policy DM line. I believe the privacy and the overlooking on the adjacent neighbour because of the scale and the height and the form of this large extension will affect the privacy of the use of the patio area and the gardens. It will have a detrimental effect on daylight, as per the policy, in the lounge, and sunlight, which is required to be maintained. I also believe that when you get out in that garden, the scale, size and form of this extension will affect the pleasant outlook of the current occupier of, I believe, number 32. And that's interpreting the policy. And that's the way I see it.
Thank you, Councillor Mumford. In terms of the scale, size and form you mentioned, there was reference from the ward councillor regarding the materials and the incongruity of the materials and the you've mentioned the form. Is it also the fact that these buildings in this area have certain vernacular, have certain features which is perhaps not carried through in the materials used?
No, I'll take the form out. I'll just go for scale and height. I'll just stick with that, so we have a more defined objection for the officers.
Right, Mr. Bailey, is that better explained?
I can see where members are going with this, so I'll try and assist. In terms of, you mentioned, Councillor Mumford, the privacy and overlooking due to the scale and height will impact on the patio area and granary. Well, I'm going to come back to the usual issue is where is that impact coming from? Is it a direct overlooking from a window, from a rear-facing window? Is it a direct? Because what I need to do is, if we're going to refuse this application, I need to articulate exactly where that harm is coming from, so then I can address that when we defend the appeal. So in terms of, it's quite difficult to say that there's privacy and looking due to the scale and height. It may well be due to the creation of a rear elevation window which overlooks the garden area, but I would say that is a normal circumstance that we get in residential development, where you have windows that you can look into the next door neighbour's garden. I mean, it's a standard practice, unfortunately. We don't have big high walls going up there. So I'm just thinking the way you articulated the grounds, I'm having difficulty looking forward to defend the appeal. So I'm just trying to say where we're going from that. And then also you say the impact on daylight and sunlight, on which particular windows or which particular area are we saying there's an impact on daylight? I'm not trying to trip members up. I'm just trying to get to a position that if you're going to refuse it, I can then have every attempt to put a ground or defend that when we get to the appeal position.
Councillor Mumford.
Yeah, okay. I think it's the overbearingness from those upper windows, because they go further back down the garden. It does say that the residents' privacy, daylight, will be safeguarded. The officer of the south has said the daylight and sunlight is going to be reduced. Well, it says it's maintained and safeguarded. And so I would like to look at those two back windows, the high ones, and their proximity to the patio now. They will be a lot closer than they were. And I would say that we have a duty under DM9 to maintain the daylight and sunlight to the windows, whether they're secondary or primary, according to that policy.
Can I bring some legal advice at this point?
With regards to the overlooking point, I mean, that's why we have often conditions are put on about glazed, those windows where you can't see out of, what are they called? Yeah, so that's to overcome the whole privacy point and the overlooking point. So that is a way of mitigating the impact when you're talking about overlooking people and affecting their privacy.
Sorry, Tyler. Can I just get Councillor Mumford to discuss which windows he's talking about, so I can at least...
Yes.
Is that okay? Sorry, just to be clear to members, I'm just trying to get Councillor Mumford to show me exactly which windows he's going on about, then we can... Sorry. This is the window I think you're talking about. Yeah. And you're talking about the oblique.
Yeah, and it's come down and it's closer.
So we're looking at this window here against this property, yeah? Yeah. Because that's the garage one. So what we're saying is overlooking there?
No, it's overlooking there. If you've got
Chairman, if it's all right, if I could comment back on that quickly. Is that
please
okay?
do, and then I'll bring in Councillor Atkinson.
Right, just members, so members are clear what we're looking at. Hopefully members can see on that screen. Just going to show the where the concern seems to sit is this window here and the impact that that has on the private patio area of this property down here. So if you convey that to the block plan here, we're talking about this window here having an impact on the private patio area of here. Now that is if that's my understanding where members are at, I could give an officer view on that, and I think in terms of the officer view is I don't think that that would be a sustainable ground in terms of an impact on overlooking. I appreciate that's where members are going with it, but in terms of that is a situation that occurs in many houses and many streets and actually occurs in that situation. So I appreciate members can have that view. That's fine. I'm just giving members an officer view that I think it would be very difficult to sustain that that is an unacceptable impact on the amenity of the existing occupants by virtue of
yeah,
overlooking.
that's understood. Councillor Atkinson, you haven't spoken yet.
Yeah, thank you, Acting Chair. I'm looking at the plan here, and I kind of agree with the officer, because the sun rises in the east, as we know, so it would shine onto the back of number 36, I mean, and then it comes round to the south, still shining onto number 36, and then by the time it's got round to sunset, it's already obscured, in my view, by number 32. So I find it really hard to see that we can actually turn this down on the grounds of loss of light, because, you know, as I say, the sun rises in the east and comes round to the south. So I don't really see how we can refuse it on those grounds. And there is a condition in here somewhere about obscured glazing, which surely overcomes the problem with loss of privacy. So I'd be quite happy to see this given permission.
Okay, are you moving there? It depends. I mean, if Councillor Mumford and Councillor Parfitt-Reid feel that they cannot find the grounds and withdraw, you can move a counter permission or you can move an amendment, depending on Councillor Mumford. What are you looking to do?
I'm not going to withdraw. It definitely says in my policy maintained. That means at the same level as it is today. I believe it will have an effect. The closeness of this window, reducing the distance between the patio and the existing property, will have an impact on privacy, and I'm not withdrawing.
Thank you. Councillor Parfitt-Reid.
Yeah, I just want to say I agree with that, because at the end of the day, I don't think it's necessarily an argument to say that in other properties, in other developments, these things, these situations don't arise. They arise. What we're trying to do is maintain this situation, and by making it like something else, we are not maintaining.
Right, if I go back to Councillor Atkinson then, so if the motion remains on the table, are you going to move an amendment to that motion?
You mean the motion to refuse? Yes, well, I'd like to move it as it is on the papers here to recommend permission.
So is that amendment seconded? Yes. Would you like to speak? Seconded? Right. So, in terms of the amendment, as I mentioned, my reading of the residential expansions SPD is that an extension on this scale should be thinking about building in features of wildlife. It should be looking at renewable energy generation. That is not currently incorporated. Right, the wildlife one. Yeah, but it's not. It's not. Is it integral? Yeah, there is an integrated element. Right. Okay then. So it's just so. Would you be happy to take the renewables element on board in your motion?
Yes, certainly.
So, first, can I see those who are in favour of the amendment, which is to grant approval as per the papers, but with an addition of incorporating an element of renewable energy in line with the residential expansions SPD? Right, those in favour? And those against? Right, so therefore it's my casting vote. So I will vote in favour of the amendment. Right? Which now becomes the substantive motion. So we're basically voting on the same thing again. Those in favour of the motion to grant approval with the small change on the renewable energy generation? Those against? And predictably, I'll use my casting vote again in favour. The abstentions, the 3. Yeah. Right. So therefore, that application is granted. Thank you. Right, if we move on to item 17 on page 112, land at Scragged Oak Farm, Scragged Oak Road, Detling. Officers going to introduce this item?
Okay. This application is for the demolition of a dwelling and outbuildings and the erection of 3 houses and garaging. The site is located to the southeast of Scragged Oak Road within the AOMB, and the ancient woodland butts the rear of the site. The nearest property is Scragged Oak House, which is a Grade 2 listed building, approximately 20 metres northeast of the application site. And Den Hill is northwest of the application site, will be approximately 26 metres from the front elevations of the proposed units. Okay, so this is the view across the site looking northeast. The existing property is relatively low in the plot. It's mainly single storey with a partial 2-storey element. Some of the outbuildings can be seen here as well. And they too are relatively small in scale. Newlands Woods and the ancient woodland can also be seen to the rear of the site over here. Can't find them. The outbuildings can be seen on this photograph, which is looking southeast towards the rear of the site, and has been taken from the existing access. This is the view of the rear of the site, of the ancient woodland, and 10910. This is the front of the site on the right-hand side of the photo, which just shows what the frontage is like there for the application site. And here is the site plan, which shows the siting of the 3 proposed dwellings and the garaging within the plot. Neighbouring properties can be seen on this drawing, and they're they're shown to be sporadic in this area as spaced well apart. The 4 buildings shown here are uniformly placed within the site with a central access and a driveway extending across a large proportion of the site. All 3 dwellings would be some 2 metres higher than the small proportion of the 2-storey element of the existing dwelling. So these dwellings would be approximately 9.5 metres in height, which is substantially taller than anything else on the site at the moment. The development would therefore result in a significant increase in the bulk and massing of built forms within a sensitive location in the AONB. It's noted that a large part of the site will be set aside for ecological purposes, but this doesn't justify the extent and type of the development proposed within the Kent Downs AONB and in an unsustainable location. The 2 reasons that we have recommended relate firstly to the height, size, design and siting of the buildings, as well as the excessive hard surfacing at the front of the site and partial removal of the hedgerow, which would result in poorly integrated form of development that has a suburban appearance detrimental to the character of the rural area and Kent Downs AONB. The second reason relates to the provision of new housing in an unsustainable location. So we'd like to refuse it.
Right, thank you. Mr. Willett. If you press the button in the middle, you have 3 minutes, and I'll let you know as you're reaching the end of your time. Cheers.
Thank you. Good evening, Chairman and Councillors. I'm Seb Willett from Clegg Architects, speaking on behalf of the applicant this evening. The existing site contains a number of derelict storage buildings, extensive hard surfacing, and low-quality scrubland to the rear. It's in a very run-down and poor state of repair, and is littered with rubble and contamination. It's seen gradual deterioration over many years, with the previous long-term landowner passing away recently. Our proposed redevelopment seeks to improve the site's relationship with the AONB by removing these existing run-down buildings, resolving the contamination issues, and reducing the overall sprawl of unattractive and derelict buildings on the site, and moving them away from the ancient woodland to the rear. Overall, this application proposes a sensitively designed and high-quality residential development that will consolidate the quality of the site and improve the character of the wider context. The scheme has been tested through a rigorous design process based on contextual analysis and local engagement. Following pre-application advice discussions, the proposals were reduced from 6 houses to 3 new homes, now arranged along the site frontage to Scraggard Oak Road. Land to the rear, which comprises over half of the site, is set aside to remain as a protected wildflower meadow with ecological enhancements. The new dwellings will also include bat bricks, swift boxes, and there is a landscape and ecological management plan on the horizon. This will represent significant biodiversity and landscape enhancement over the existing scrubland and dilapidated yard. The proposed dwellings have been designed in order to reflect the local architectural vernacular, which is fairly eclectic, but has an overall character of timber-clad barns, rendered farmhouses and brick detailing, arranged in formal farm courtyard compositions. The proximity of the neighbouring dwellings, including the Grade 2 listed dwelling, has been considered throughout the design and informed the approach to our massing and detailing. The 3 new dwellings are arranged around a modest shared courtyard. Plots 1 and 3 are used bookend elements to create a sense of enclosure to the overall composition. Plot 1 is intended to read as the farmhouse, with 2 and 3 reading as subsidiary barns, with predominantly single-storey front elevations. We engaged with the parish early on this. It's been supported by the parish council and the ward councillor, and they've commented on the high quality and bespoke nature of the design. This reflects the high standard of architectural vernacular in the area established in the parish, and these dwellings, if permitted, will be detailed and built to the best standards of sustainable modern construction. Likewise, the proposed landscaping has been designed to reflect the best local environmental characteristics. Where low-quality trees and hedgerows are to be removed on the site, they will be replaced with appropriate native species planting. This is further improved through extensive wildflower meadow to the rear, which creates a rich pattern of varied ecological habitats across the site, connecting to the ancient woodland beyond. The planning policy allows for redevelopment of brownfield sites and encourages proposals to conserve and enhance the AONB. Overall, we consider the proposed development to make very...
Mr. Willett, sorry, you've reached the end of your 3 minutes.
Thank you, Mr. Chairman.
Right, members, anybody wish to... Councillor Chapelton. So seconded. Okay, so it's moved and seconded that we refuse this application as per the papers. Can I see those who are in favour of that motion of refusal? Thank you. And those against? And abstentions? So that application is refused. What was your vote? I abstain. Right, move on now to item 20 on page 142 of the agenda, and that is Starbridge Kennels, White House Farm, Starbridge Lane in Linton. So can I have the officers introduce this item, please?
Thank you. Through the Chair. The application seeks a variation of Condition 2 of the 2017 permission to allow the mobile home on site to be occupied for an additional 2 years until the 19th of March 2023. The reasons for this are twofold. One is the personal circumstances regarding the children's ages. Currently that would mean that they would be moving schools at the exact same time of trying to find suitable accommodation elsewhere. And two, to allow the applicant to remain in close proximity of the existing viable business, allowing it to continue to operate at full capacity. Just a quick overview of the site. This is from their driveway viewing into the site with the dwelling in the back, the main dwelling in the background. That's front of the mobile home itself, side elevation. Those are the kennels, and that's the rear elevation of the structure of the mobile home. The kennels on site are owned and run by Peter and Susan Freeman, aged 72 and 69, who occupy the main dwelling. Their daughter, Sarah Freeman, resides within the mobile home with her 2 children, 9 and 4, and Mr. Fidds. The proposal site is not considered to be in a wholly sustainable location in terms of being predominantly reliant on the private motor vehicle to access basic amenities and services. However, given the personal circumstances of the proposal, including the desire to support an existing rural business and the fact that the applicant would be living at their place of work, no objection is raised on these grounds in this instance. There is still 1 year and 3 months remaining on the original temporary permission, and it is accepted that continually granting extensions to temporary permissions is not ideal. However, the council fully supports its businesses in the borough, and in this instance, it is considered that granting an extension to the temporary permission will allow the business to continue to run at maximum capacity, with the applicant able to reside at the business. Ultimately, this will allow the applicant and her dependents to be in the best possible position to either submit an application for a permanent dwelling in this location or to find suitable accommodation elsewhere in the borough. And it is considered there is sufficient justification to allow the temporary permission to be extended and that there are no policy grounds to refuse the application. Thank you.
Right. Can I have indication from members of lobbying on this application? Councillor Mumford. And also for information, we actually have an urgent update relating to this application in front of you. Right, we've had... I think Councillor Webb is waving, but... Okay, if you come up, you know the drill on 3 minutes.
Thank you, yes. Sorry. Linton Parish Council were under misunderstanding of the adjourned meeting and didn't get their application in to speak. So they've asked me to try and sort something out for them. So under the terms of the original application, excuse me, I'm reading the writing here, there was temporary permission for the station of this caravan for a viable business. And then it would be reverting back to the condition that it was in before the caravan was put in place. What the parish council are wondering is why the sorry, I'm trying to read the writing here. Sorry about that. The viability of the business is in a bit of question. There was a letter from planning officer on the 7th of October to the agents, which appeared on the planning portal, saying that in your statement you have suggested that the client financial position has worsened, which I do not think is helpful in this instance. And it looks at there is no need to extend the temporary permission to continue living there. And they wonder why there is no roadmap of progression for the 2-year of extension. They just hope that the business will improve, and there is no guarantee that the business will pick up. There is also, the parish council have looked that when the original planning application was on the planning portal, some information was actually blanked out, and therefore there is some, debate whether there is any reason for this to be missing, or what the reason for this to be blanked out on the application. Also, you talk about there is 1 year, 3 months left on the application. It's nice to be prepared, but given the condition of we're looking at the business case, you don't know whether there is going to be the condition in a year's time of whether this business will still be going. So, why the application now? What's the reason behind it? And unfortunately, I've just run out of time, I realise. Sorry, okay.
Right, thank you, Councillor Webb. On the point that Councillor Webb has raised, viability is a material consideration because it's similar, if you like, to an agricultural mobile home or something like that. And if you can't actually justify the viability of the commercial operation, it could raise some question marks. However, I want to bring in Councillor Mumford now, who had indicated.
Bolton on Chelsea is 100, 200 yards down the road, so I'd not actually seen the mobile home in question. I went down there this afternoon, and it sits comfortably in the countryside. It can't be seen from the road. It is timber, as you can see. But what is not being shown on those slides, this is where two policies meet. Whichever direction you look from that mobile home, you see the G&T sites. It is crammed down Stolbridge Road, all of it, apart from this sort of kennels, cattery, is G&T. And so it's a bit ironic that I look at that and see that it's only got temporary permission, but I do understand that two policies meet and one allows and one doesn't allow. It is not at this current stage causing a problem. There's been no complaints about it or the residents within it, and it sits comfortably in the countryside. So I'd be happy SP17.
So you're moving something, Councillor Mumford?
Yeah, I will be. I spoke to the business today, and they still want to keep it running. It's been there since 1984. We support businesses in the countryside, and I see no reason whatsoever to refuse this application. And I would like to move that it is approved as per the officer's recommendation.
And that's seconded by Councillor Kimmats. Do you want to say anything or not? On the point raised by the parish council around the viability, I mean, it could be argued that by allowing the continued stationing of this mobile home, it actually helps with getting the viability back on the side. So I think there's a justification in an argument there. Sorry, Councillor Chapel-Tay wants to come.
I wish to ask a question of the officer. It's not an eyesore and it's contributing to rural business. I think there are a lot of good reasons why we should say yes. I also am not very enthusiastic about forcing families with young children to move at the wrong moment. Having said that, how do we ensure that this temporary permission doesn't keep getting extended until it becomes permanent?
Okay, so just to quickly go through some of the issues as they've been raised. Regarding the redacted info on the planning application, I think that was perhaps my fault. There was a signature on the document which got redacted. I didn't pick that up, so that's perhaps why it didn't get distributed to the parish council. With regards to the business case, I have requested additional information from the agent acting on behalf of the applicant. They have provided additional information indicating that the business is still profitable. We have consulted Richard Lloyd Hughes, who seems to indicate as well that just, although he didn't provide formal comments, just that the business appeared to him to be viable. Perhaps my colleague James can clarify on how we prevent temporary permissions rolling over.
I mean, the chair picked it up at the very start. We treat these as a sort of an agricultural, new user, new business coming on site. So what the policy says, we grant a temporary permission on a mobile caravan that allows them to substantiate the business, grow the business, develop it. We then look at the viability. So we look at a function and financial test. That's what we usually call it. So in terms of granting this, we've treated it slightly different. In terms of this is for kennels. Is there a need for a full-time worker to reside on site? We've previously concluded that yes, there is, so we can support the business. To answer your direct question, how do we stop it? Well, obviously, by imposing a personal permission on the individual, that if someone else occupies that site, they'd need to come either back into planning and review their function and financial test to see if it's viable, but notwithstanding that at the end of the period of time, if they haven't come forward with what I would normally expect is an application for a permanent dwelling. That's how we normally, the functional test and the viability test works. You come forward in 3 years, or in this instance, another 5 years. They then come forward, they've built up some money. We then come forward, is the business still viable? What's its outlook going to be? And in that case, if that ticks the box, we'd say, yes, we should grant a small-scale building that meets the functional need of the dwelling. So not a big, large house. It would be a dwelling that meets the functional need.
I think it's understood.
Hi, yes. I think, it is a perfectly pleasing building. It is not an eyesore. I just think this is all just a little bit messy. Why are we not encouraging this applicant if they have a business that's been there since 1984? Why are we not encouraging them to make a permanent application rather than coming backwards and forwards? And I totally agree with Councillor Chapel-Tay that we shouldn't be encouraging families to move at the wrong time. And to me, it would be better to give some stability to this family rather than have this ongoing situation.
Well, I mean, I suppose I would argue that it's the first case of seeking to extend the temporary permission. I mean, it has been put to the agent what the long-term plans of the applicant are. They although obviously these are subject to change in future, they have indicated they don't wish to seek permanent residents on site. Obviously, that their minds could change in the meantime.
Thank you for that. And I think this is also tied up to the viability issue that was discussed earlier on the parish council row. So hopefully that there will be a consolidation and we may see a different application in the future. However, we have had a motion for approval moved and seconded. Can I see those in favour of approval? Right, that is unanimous and permission is granted. Thank you. Right, if we move on to item 22 on page 156 of the agenda, and that's Bimbury Cottage, Bimbury Lane, Stockbury. Officer, introduction, please.
Thank you. Through the Chair. The application site comprises of a semi-detached two-storey cottage located to the northwest of Bimbury Lane. Bimbury Lane is located within the Kent Downs area of outstanding natural beauty and in policy terms is located within the countryside. Planning permission was granted in 2015 for the same extension as proposed in this application, which was not implemented. The applicant has recently added horizontal weatherboarding to the upper floor of the front of the original dwelling. This has been subject to an enforcement case and subsequent withdrawn planning application. Planning permission is required for the cladding of the property as it lies within the AONB. Just the front elevation of the dwelling, the rear elevation, another rear elevation, the side elevation, and the existing and proposed plans, and a site location plan. The current application seeks permission to add a two-storey side extension and a single-storey rear extension. The external finishes of the proposal will comprise of grey slate tiles to match the existing roof, large feather-edged board cladding painted black, white UVPC double glazed windows and doors, and facing brickwork to match the existing. The large feather-edged board cladding has already been erected on the front elevation of the original dwelling. It is not considered that the additions to the dwelling have a detrimental impact upon the host dwelling or the wider area. In regards to the proposed materials, in particular the proposed weatherboarding, the Parish Council have raised concerns regarding the use of vertical boarding. For clarification, the weatherboarding erected is horizontal in design. The landscape and conservation officers both confirm that although the materials would be different to the adjoined neighbouring property, the Kent Downs AONB has a rich tradition of half-timbered and weatherboarding properties, and that the large feathered-edged board cladding in black would be of a good quality design, colour and material that would not detract from the character of the area and would not be detrimental to the AONB. The Kent Downs Management Plan also reinforces this assessment. It is not considered that the development has a detrimental impact upon the amenity of any neighbouring properties in terms of loss of light or overlooking, nor would the development detrimentally impact upon parking in the area or the wider highway network. As such, it is considered that there are no policy grounds to refuse the application and an approval with conditions is recommended. Thank you.
Right, thank you. Can I have indications of lobbying, please? There are none. Right, Councillor Kimmons, you wanted to speak.
Yeah, I just wanted to ask a question. In the papers it says part retrospective. Can you tell me which is the part retrospective?
That the weatherboarding, the change of materials is the retrospective. The additions have not been carried out yet.
So it's the cladding on the front there, the black.
Yeah, that's right.
So he wants to convince a neighbour to do it because I think it looks nice.
Right, can I bring Councillor Chapeltay in, please, now?
When I look at the objections to this, they're pretty minor. That there is the issue of it being on a blind corner, but it's there, the house is already there. Extending it makes no difference to its location. I kind of get the point about weatherboarding. This is a minor point, but speaking as someone who was born in Kent and has lived here for over 5 decades, black weatherboarding traditionally was on agricultural buildings. White weatherboarding or unpainted is what you normally found on houses. So I get that the black weatherboarding is actually not very appropriate. Whether or not it's sufficient to hold out on planning permission over the colour of the weatherboarding is, however, a debatable point.
Sorry, bring the office.
Sorry, just to be clear, I think there was some confusion with the parish council. I think they felt it was vertical weatherboarding, which they did not find acceptable. I think the case officer did put that to the parish council, but they did not have time to withdraw the request to call it into committee.
Okay, do we have a motion at all? Anybody willing to move something? Councillor Mumford.
I agree that black is agricultural and white is residential. So to sort of smooth that over, can we condition that the weatherboarding be a certain colour? Can we condition that tonight and let it go forward? Nod or shake your head.
Yeah, I mean, the application as it is currently framed is partly retrospective for what is there, which is black. We need, I mean, is it reasonable to say that black is so incongruous? And I'm sure we can find examples in Stockbury where there is some black weatherboarding on residential. So I think it is stretching it a little bit. And
so I'd like to recommend as the officers, I'd like to move as the officers have recommended.
would you be willing to incorporate the renewables policy as is in the SPD, because it's about the only hook we actually can get to request it?
I'm unlikely to say no, so it's yes.
Councillor Kim, second. So those in favour of... Sorry, Councillor Kimmons.
Yeah, I did want to speak. Going back to what you said about the white buildings and the black buildings, it depends how far you go back, because go back to 1944-45, everything was black because they had to paint it black because otherwise it would have got bombed.
Just ask one point. In terms of the renewables, is that a separate condition you're requesting, and is that an issue that you're delegating to the head of planning? Or is
it's delegated to negotiate it in line with the residential extensions SPD, where there is some clarity there. Actually,
is that to negotiate or to impose a condition?
It's to impose a condition. So yeah, the delegation is to achieve a technically feasible approach. Is that okay? Right. Okay. Right. It is, I mean, what we were unwilling to do at this point was to actually discuss what it comprises. Therefore, there will need to be discussions between the case officer and the applicant to work out what form of renewable energy will be utilised, whether it's an air source heat pump or whether it's a PV or whatever. Okay, right, thank you. So can I see those who are in favour of granting planning permission with the small amendment? That is unanimous, and yes, with my vote. Right, thank you. If we move on to the next item on the agenda, which is item 23 on page 163 of the agenda, and it's a tree preservation order application for St Stephen's Churchyard, Church Road, Tovel.
Thank you, Chairman. This is an application for a crown lift to 6.5 metres on trees T2, T4, T5 and D6, which are lime trees within the churchyard, and a crown lift to 5 metres of T10. And the application is submitted because it's an NBC application. Page 164 of your papers sets out exactly what is proposed. In paragraph 602, T2, T4 gives an assessment of the condition and the visual amenity of those trees, which it says it's good, clearly visible, condition is fair, showing minor signs of deterioration, and life expectancy is long. And likewise with the sycamore, contribution to public amenity is good, condition is good, and useful life expectancy is very long. The officer concludes that the proposals are likely to be detrimental to long-term health of the trees and their contribution to amenity, and recommends that the requested crown lift be agreed, and then sets out the conditions on that basis. Obviously, this will have an impact on the visual amenity, but the officer concludes that those works will not harm the longevity of those trees. Nothing further to add, Mr. Chairman.
Councillor Mumford.
I'd just like to move as the officers recommend.
Seconded. Has anybody been lobbied on this one? I doubt. No. So therefore, we've had a motion moved and seconded. Those in favour of permitting the TPO? That's unanimous. Thank you. Right. We move on to appeal decisions, which are on page 168 of your agenda. Mr. Bailey.
I think that in terms of the appeal record, we had a bit of a bumpy start at the start of the year, Q1. That was as a result of quite a significant activity and overturns on our G&T applications. I think we've pulled that around in terms of Q2, Q3. Currently sitting at about 68% of success rate on appeals. This sets out there's quite an increase in appeal activity. A lot of them are successful. There is one, obviously, Brunswick Street, which was allowed on appeal. I won't go into too much detail on that, but we were treating the site as a whole entity, 4 separate sites, and this actually one was determined and refused. The other 4 were going to be determined in the same light, but the applicant withdrew them due to some irregularities on the application. Our argument was the lack of contribution to affordable housing as a cumulative total. The inspector said, well, I haven't got those other decisions in front of me, so I can't make that decision. Therefore, I have to do this on a standalone. Your only ground was lack of affordable housing contribution, and therefore that fell. So I think that's kind of an understandable basis. Apart from that, I think success rate is good and has been pulled back more recently.
Right. Have members got any questions on the appeal decisions? No. Right. If we move on then to formal enforcement action tracker on page 175, Mr. Bailey.
Thank you, Chair. This effectively, you've got a large-scale printout sheet. Unfortunately, they print it in black and white on the papers. This effectively just looks at our formal activity, just gives members an update of what's in the system, where we are, how we track it. And again, this is not awaiting enforcement notices. This is action has been taken on these applications, and obviously the red flags are the ones that have either passed or need potential action, because obviously they've passed the compliance period for the enforcement notice and now they're into the next stage. That just sets out, and it gives you an indication in terms of where that there are appeal or lodged on others. In terms of, you'll see in terms of unicumes, quite a large number of appeals coming forward on that. Some applications have been updated, obviously, if you turn the page with the key in blue, where as a result of decisions, appeals have been allowed, the enforcement notice was quashed. They will come off this tracker the next time you see it, so it just gives you a sort of an update position in terms of where we're going with our appeal. You'll notice there are quite a lot of reds coming forward on the system, quite a lot of work. There's a lot of activity that needs to be carried out by the enforcement team. We are limited. We have to look at prioritisation and how we deal with these sites coming forward, along with our day-to-day work in terms of investigative work. And we recently went through an enforcement audit, and there are some matters that we need to pick up through that. But as I said, we look at these through a priority tracker so we can move forward schemes on a basis. Thank you, Mr. Chairman.
Right. Do members have any questions, or are they just noting progress? Right. Noted. Thank you all. Oh, Councillor Mumford was coming.
At this beginning of this meeting, I spoke to the chairman. I wanted to put a motion forward. He said do it at the end of the meeting, so I'm now here. If those that were here remember at the beginning of this meeting, 2 weeks ago, a week ago, we turned down the application for the Springfield site. And from that, I wanted to put a proposal forward that this committee proposes that we come up with a tall buildings policy. Now, I've spoken to Mr. Jarman. He agrees that we need one. It's something that we haven't got, and we weren't able to look at any policies on tall buildings. And we experienced the same on the SPI. So I'd like to propose that we put that motion forward.
Right, so this is a recommendation to our Strategic Planning Committee, to SP. Yeah, okay.
Yeah.
Members content that we do that? Okay, so agreed unanimously. Okay, thank you.
I do have a second one.
Councillor Mumford.
We went through Len House, etc., and we came up with planning guidance for the sites that we wanted to go or felt would go forward, and we came up with expensive planning guidance that went through SPI. Taking into account what Councillor Harwood said about the Springfield site, that has sat there redundant, and for a reasonable amount of time it's attracting hooligans and all sorts of things. I would like to propose that we ask SPI whether they would consider coming up with planning guidance for the Springfield site in conjunction with the ward councillor and the current residents.
Yeah. I mean, interestingly, we did have a development brief for the whole of the Springfield site, and it was very good, and everybody had fed into it. But then we were told it was obsolete because it was too old, and it all got messy. However, I think an update is long overdue, and there is a debate there as to whether we should actually have an allocation on that site, because you're right, you cannot have a derelict building there for much longer with all of the antisocial activity and so on it currently attracts. So yes, our members agreed that we look at a development brief approach for the remainder of Springfield. Yeah, because it's interesting. It's not just the buildings. There are components of that scheme that should have gone ahead, such as gardens and nature reserves and so on. None of them have to date, and they've been been compartmentalised, and that has meant that all the goodies have been left off, really. Councillor Mumford, sorry, and then I'll bring in Councillor Atkins.
I've got one more. Could I ask the planners to organise a spokesperson meeting early next year, as we haven't had one, I don't think, in 2019? Oh, that's all right. It's often you don't listen to me. Well, I'm asking that can we have a spokesperson meeting, because I'm not sure we had one in 2019. We may have done, but it's been a long time, and we've got a whole list of things early next year.
Yeah, it's a good idea. We'll set one up within the next week or so, probably just after Christmas now, but we'll see how we go.
Yeah, I was just chatting with the legal officer as to whether there's been any constitutional amendments that have occurred in the interim that I'm not aware of in terms of the planning spokesperson. So, dare I say, I'm looking over to my right. I'm looking over to my right because I'm just checking that motion is coming forward. Have there been any constitutional amendments with regard to my understanding of what the planning spokespersons were at the time?
Without looking at the Constitution, I think there was a change, which is in terms of call-in of planning applications.
So, is the Constitution still... I mean, what I'm trying to do is get clarity. Is there still a spokesperson's meeting on the basis as a result of... Because I do recognise that the call-in powers were delegated directly to the planning spokesperson's members. That constitutional arrangement changed, and that allowed effectively ward members to call in those matters. So I'm just checking to see, is there a constitutional function now for spokespersons? I'm not saying I know. I'm just saying, I'm just making the point to the legal officer, is there a function now in the Constitution for planning spokespersons?
I'm not going to lie, I don't really know. I'll have a look into it, but I know that there was some discussion earlier this year about spokespersons and the political spokespersons groups.
Right. I mean, there have been spokespersons meetings ever since there's been planning committee, as far as I can recall, and we are not here talking about callings or anything. We're talking very much about the management of the committee. So I don't foresee there being an issue, but I will leave it to the legal team that if there is some problem. But hopefully we will have dates sent out in the near future. Councillor Atkinson, you want to come in?
Yeah, thank you, Chair. Going back to the Springfield site, I don't think you mentioned the community centre. I mean, that was originally intended to be sort of, well, what's the word? Built, but it wasn't. I mean, I recall years and years ago, we had the Ringleston Area Community Association, and actually some foundations were laid for a community centre. I think it's off Edgerton Road. I'm not 100% sure now.
They're still there.
It's still there, is it? Still just the foundations. So is it worth sort of looking at that to see if maybe that can be built? But also related to the Springfield site, I mean, the proposal that we rejected last week, 170 flats, only 85 parking spaces. Now, as council...
Well, that's a completely different thing. I mean,
No.
you're inventing a policy more generally, and it's a very sustainable site close to the town centre and a train station and so on. I really, you know, I think it has to be on its merits as we come in.
Yeah.
And
But I'd
coming
like
on
to
to the
move-
point around the community thing, what we have been doing is collecting Section 106 money, and there is a pot of Section 106. Currently, the proposal is a redevelopment of the St Faith's Hall at the top of Monkson's Lane, and that is the approach that's being talked about, because I think with the loss, if you like, of the development brief, the site was compartmentalised and sold off in very small plots where there was no room to put the open space or to put the community facility, and that has led us into all sorts of problems.
Yes, okay, but I was also interested in the parking policy generally, because as Councillor M. Rose has said a few times in various committees, our current policies mean that there's not enough spaces for cars to park, which then leads to neighbour disputes. One of the commonest things that she dealt with as a magistrate and as a mediator is disputes between neighbours over parking spaces. So I'd like somehow in the parking policy DM23 to make, as part of the review, to make sure that there is enough parking. I mean, we talk about the London...
I mean, if I may, I mean, the local plan discussed this ad nauseum. There was a very long discussion around parking standards, and you have to evidence and justify where they are. They have to reflect national as well as local conditions. However, Kent Design, as pertains to parking, is currently being reviewed, so there may be some changes afoot coming through that, which might be helpful. But can I bring in legal as well?
If I can just say, I think we're starting to stray well off the agenda at the moment. I think when you raised the point with regards to the community centre, I think that could be picked up in the development brief. But I think going into the parking and all that is, I think, way outside of the planning agenda. So if we can just stick to that, I think we've got a couple of things going forward to strategic planning. We know that parking is, as the chair has pointed out, in the pipeline with SPY.
Right, that just leaves me to thank you all and say good night and have a safe journey. Thank you.
If I can say thank you for Councillor Hull for stepping into the chair at very short notice and doing a very good job. Thank you.